Influential writer in this field in recent years has been Ronald Dworkin. His criticism of legal positivism begins with the observation that courts must often decide cases for which there are no precedents, and nothing in the record of social facts, so-called, that would be sufficient to settle the matter. One instance cited by Dworkin is Riggs versus Palmer, which had to decide whether a murderer nonetheless was still to enjoy what his victim had bequeathed to him in a will. Now, the maxim according to which, quote, no one is to benefit from the commission of a crime, close quote, was not in the settled law of the jurisdiction, and in any case, it's a patently moral precept in character. But it was just this reasoning that led to the decision in Riggs. To summarize the conclusions reached by Dworkin in his analysis of law, the authority and validity of law result from its embodiment of moral aims that are widely shared within the community and of a nature to justify the values and practices of that community. In Riggs, the court achieved the best outcome, defined as the one that matched most closely the moral principles operative within that community at large and at that time. On this understanding, says Dworkin, quote, judges should decide hard cases by interpreting the political structure of their community, trying to find the best justification they can find in principles of political morality for the structure as a whole, close quote. Now, some are going to see in this little more than advocacy, indeed, advocacy of judicial activism, even an apologia for the status quo. I want to pause here to say that Professor Dworkin has never concealed his support of legal activism. But I should think that in the Lincoln-Douglas debates, for example, Douglas would have made very good use of Professor Dworkin's understanding of the nature of law. Much of the South, understood surely as a community, accepted slavery as a property right, and more important, the right to make that judgment as a state's right. So that was endemic to the culture, widely shared values. To some extent, Dworkin's theory is a descendant, if not an acknowledged one, of that legal realism that flourished in American jurisprudence under such defenders as Oliver Wendell Holmes, Roscoe Pound, Jerome Frank. Holmes famously reduced the concept of law to that which would allow him to predict what judges and juries will decide in a given case. The best understanding of law on this account is an instrumental one. Law is just a tool designed to achieve certain desired outcomes. It functions in such a way as to make easier or more efficient the attainment of social goals. Its authority is not found in moral precepts, even in tradition or custom. Its authority just is the act of deciding cases. Jerome Frank was himself a federal judge. In one of his lectures on legal realism, he discusses a Supreme Court case settled by a 6-3 decision, and he asks, from the petitioner's point of view, just what was the law. As Frank observes, until the court ruled, there was no answer whatever to the question. Quote, this is Frank, law then, as to any given situation, is either A, actual law, i.e. a specific past decision as to that situation, or B, probable law, that is, a guess as to a specific future decision. Now, Kant, as might have been guessed, composed a most analytical exposition on the nature of law, understood as part of the metaphysics of morals itself. The heading under which we find his philosophy of law is, quote, the science of right, which, he says, has for its object, quote, the principles of all the laws which it is possible to promulgate by external legislation. It is from this science that the immutable principles of all positive legislation must be derived by practical jurists and lawgivers. And what is that principle? Well, as Kant puts it, every action is right, which in itself, or in the maxim on which it proceeds, is such that it can coexist along with freedom of the will of each and all in action according to a universal law. Well, law then is derived from a principle, and the principle is one that seeks to preserve and honor the moral liberty of rational beings, consistent with the freedom of all such beings. That freedom, too, comes under the direction of a universal law, which, as we have seen in the lecture on Kant, is a moral law. With Kant, we are returned again to the law's moral purposes, derived from the idea of freedom and the dignity of beings who are rational as such. Of rights, Kant asserts that only one is a natural and inborn right. All others are derived from positive law and tradition. So, what is the core right, the inborn one? Quote, freedom is independence of the compulsory will of another, and insofar as it can coexist with the freedom of all, according to a universal law, it is the one sole original inborn right belonging to every man in virtue of his humanity. There is indeed an innate equality belonging to every man, which consists in his right to be independent of being bound by others to anything more than that which he may also reciprocally bind them. These lines provide a foundation for one of the most influential works in contemporary philosophy of law, John Rawls's A Theory of Justice. As with Kant, Rawls's goal is the preservation of freedom from the compulsory will of another. The reciprocation discussed by Kant appears in Rawls as a fairness criterion, justice as fairness, grounded in that principle of equal liberty that gives no one more extensive freedom than that possessed by others. And Kant's categorical imperative, in a somewhat quirky way, supports, or at least is intended to support, what Rawls calls the difference principle. Social and economic inequalities should be arranged so that they are to the greatest benefit of the least advantaged before they improve the condition of the more advantaged. Well, I should say, for all its celebrity, Rawls's A Theory of Justice, I must say, is disappointing and incomplete. It's surely not a Kantian maxim that the claim one has on the general resources is proportioned to the degree of disadvantage. There are just deserts in Kant, after all, such that one might well have earned one's disadvantages. And what can be said of equal liberty if its exercise leads to the very differences in social and economic conditions that are then to be cancelled or reduced via the difference principle? All due respect to Rawls and his work, but you see, more questions raised than answered. There is a small step, actually, from the position according to which law is no more than a social instrument to the very use of law to secure social conditions dictated by theories which, rather than outcomes of rigorous criticism, are presented as if they were protected from criticism. In the end, just in case we are vigilant and lucky, law is an ordinance of reason, and it is promulgated by one who is responsible for the common good. Now, what question does this leave wide open? The question it leaves wide open is just what is the common good? It's not within the province of philosophy of law to determine what, given the nature of human nature, would be the common good of all. And in order to address that question, one is inescapably led back to fundamentally moral considerations, such that even if one were to accept a positivistic distinction between morals and jurisprudence, moral philosophy and philosophy of law, and were simply to accept that the function of law is to secure ends compatible with the good of the community, with the values of the community, etc., we would still be driven back to a critical assessment, a critical identification of just what constitutes a benefit to all, what constitutes the good of the community, what would be the means by which to measure and assess the extent to which the freedom of one has been honored in a proportional way to the freedom of all. Philosophy of law, like philosophy itself, is extremely useful at the level of criticism, makes no promises really, and shouldn't make promises at the level of great and abiding and true discoveries. Philosophy of law is alive and well, and by the way, in case listeners are interested, natural law theory, around for so long and then replaced, seems to be sneaking back in, very often under disguise sometimes in the darkness of night. Stay tuned.